Hi, this is Mike Lawrence, Greater Louisville Association of Realtors, and I am doing the industry update for evictions. It's hosted by the GLAR Affiliates Council. And before we get started, I would like to do a little shout out to Lisa Stevenson, who is the outgoing CEO at GLAR. I've known Lisa for 20 years, and she has done a great job. I hope that all of you are as happy with her as I am. We have a new lady coming in, a very nice Linda Fernandez. She's the new GLAR CEO. She'll be starting in April, and I hope to meet her soon, and I wish her the very best. Um, some of you know me, some of you don't. Again, it's Mike Lawrence, and my firm is Lawrence and Lawrence, and I'm the guy that does the real estate. Um Jason does all the domestic, and Andrew Weeks does the PI and employment law. And if you want to call us about any of those, especially the real estate stuff, give me a call. Now, just a couple of highlights. I looked at the GLAR numbers over the last month or so, and it's really huge. I mean, the year-to-date solds are up. Days on market is 30 days, a little over 30 days, 31. Sale price is up $24,000 on the average year over year. Closed sales are up over 6%. You guys are killing it. And I know COVID is a big concern out there, but for the buyers and sellers, it's not killing your business. Really, as I look at these numbers, it's actually not hurting you at all. The one group of realtors that it is hurting is the realtors and their investor clients who are landlords. Okay, um, landlords have to do evictions occasionally because people aren't paying, and over the last year, a lot more people haven't been paying. So what we're doing today is the eviction updates because, quite frankly, in Jefferson County, eviction law or practice has changed a lot. So the first thing we have here is your forcible detainer complaint. If you look up, you've got court, county, division. In division, you can put eviction or forcible detainer. A lot of people, it's the same thing. A forcible detainer is an eviction. Okay, so if your client, if you or your client is trying to do an eviction by yourself, you need to get the forcible detainer packet from the district clerk. Um, I'm going to give you just a little bit of history on this. 30 years ago, most folks owned investment property in their own name. Okay, and then about 20 years ago, they started realizing that if you wanted to protect your personal assets, you would start putting your property into uh, corporations, LLCs, partnerships. Okay. The only downside to that is if it's not in the owner's personal name, they have to have an attorney. If it's in an LLC, a corporation, partnership, etc., you have to have an attorney file it, and you have to have an attorney appear in court. Otherwise, they won't hear it. So as we go through this, you have to be able to tell the court, basically, did you have a written lease? 99% of the time, there's a written lease. Uh, if you've got the rent roll, it's really easy to figure out how much is due. Now, eviction court has nothing to do with collecting your money. You don't get money in eviction court. You want to get money, you have to go somewhere else. Until COVID. And then what happened was people who were behind, if the eviction was filed, they could file for eviction assistance, and basically the eviction assistance folks here in the county would pay the past due rent. And right now, I think they're paying back to April 2020 and forward 2 or 3 months. So the good news is the tenants get to stay without having a blot on their record, and the landlords get their money, which is something that they didn't used to get, right? Before COVID, if your tenant owed you 3 or 4 months rent, you had to chase them. Now you file your eviction complaint, and if they go through the process with the eviction assistance folks, the landlords will get their money. So if you've got landlord slash investor clients, or if you're a landlord slash investor, don't be afraid to file the eviction, because that's the one way you can get your money, assuming that your clients will contact the eviction folks. And the judge, every day in eviction court, the judge starts by saying, we've got this eviction assistance available. She provides the phone numbers, and the tenants can contact those folks. The matter gets passed, and hopefully you guys get paid. But before you do that, you have to file your complaint. Okay, again, it says forcible detainer. That's your eviction complaint. There's an eviction notice, right? These folks have the right to say, I'm not behind, because not every eviction has to do with not paying the rent, right? Some evictions have to do with not paying for the utilities, right? Under the lease, they were supposed to put the gas or electric or water in their name, and they didn't. And the landlord don't want to pay for it anymore, the property owner. Or they're selling drugs, or they're, doing other criminal activity, and you want to get them out. You still have to give them notice, and they have an opportunity to respond. And that's what the eviction notice lets them know, is they've got the right to a trial if they ask for it, but they do have to ask for it. So that's what the second piece is for. And again, when you fill it out, it says court district. It's district court, and the division is, you can either put in eviction or forcible detainer. I always put in eviction. It's the same thing. Now, something new that's come up in January is the civil case cover sheet. We've got that on there, and you'll see down here, it's in the middle with the little orange arrow. It says forcible detainer / eviction. You got to check that box. That's what you're asking for, okay? So court, district, county, Jefferson division, either forcible detainer or eviction, put it in there. But they do require the civil case cover sheet. Now, if you're filing online, attorneys generally have access to that. Most private individuals don't. So if the attorney is filing it, they'll probably do that. If you're a private individual, you need to fill that out by hand and file it when you go to court, or when you go to the clerk's office to file. Okay, now this next one is a big deal. Okay, this is the verification of compliance with the CARES Act. Okay, you have to confirm that you have given them 30 days notice that they haven't paid rent. It used to be, for anybody who was renting property prior to February 2020, the rule was, if they didn't pay their rent, you gave them a 7-day letter. You didn't pay your rent, pay it in the next 7 days, or kicking you out. But what it is now is you have to give them 30 days, which is what you used to have to give them for everything else. Okay, so now everything, there is no 7-day letter. If your client still has a 7-day letter in their form file and they're thinking of using it, they can't. 7 days won't get you an eviction. You have to send them a 30-day letter, and you have to fill out the verification of compliance with the CARES Act form. Okay. If you don't fill it out, they won't accept it. And more importantly, you will have wasted your filing fee. So make sure you go through it. It doesn't apply to everything. For example, if it's a commercial property, you don't have to worry about it. The second part of the form is the actual CARES Act explanation of terms. Okay, this has to be included. It has to be sent to the tenant. Okay, and it says temporary moratorium on eviction filings, and it explains to them what's covered, what's not covered, and it's, you know, it's 2 pages, but it has to be included. If you don't include that, you won't get your eviction. Okay, if you want to get your eviction, you have to include it. It's that simple. And you don't have to fill that part out. You just have to attach it to the verification. The next thing we've got is the judgment again, and that's got court filled out, district, county, Jefferson, division, eviction. You put it in there. It's got to be filed along with your complaint, and assuming the judge finds in your favor, she'll sign the judgment, and you can proceed. Now, 2 things have changed big time. The most important is, for the last 29 years and 10 months, essentially, if there was a non-payment of rent eviction filed in Jefferson County and the tenant failed to appear, the landlord or their attorney would ask the court to take the matter under submission, or basically just say, Judge, please submit. And for the last 29 years and 10 months, the judge would look around the courtroom, ask if anybody was there for the tenant, and if there wasn't, the judge would sign the judgment. That doesn't happen anymore. In the last 2 months, what's happened is the court has determined that a landlord or their representative has to be available to testify in order to get the judgment. So, if you are a property manager or an investor, or basically, even if you just have 1 unit, if you are filing an eviction, you have to be available on the date of the eviction hearing, so that when the case is called, you can either call in on the phone or Zoom in and offer testimony as to the basis for your claim. They didn't pay their rent, or they were committing criminal acts, or whatever the breach of the lease was, because without a representative from the plaintiff, the judge will not enter a judgment. Okay. It used to be we didn't have to worry about that unless there was somebody showed up and asked for a hearing. But now, in order to get your judgment, somebody has to testify, property owner, property manager, etc., on behalf of the plaintiff. Can't be the attorney. Attorneys don't testify. To establish the basis for the default so that the judge can sign the judgment. Now, what happens after the judgment is entered, and this is something a lot of folks and I've got the Jefferson Court thing here about people showing up. After a judgment is entered, the tenant has 7 days to vacate the premises. At the end of 7 days, if they're still there, you can't just go and kick them out. At the end of 7 days, you have to go back to court and ask for a set-out order, which costs you another $60 because the sheriff is involved. And The set out order is usually signed within 2-3 days of your request. Once the order is signed, it's up to you to contact, I say you, it's up to the property owner, property manager, investor, etc., to contact the sheriff's office and schedule the set out. Okay. It's important to know that the sheriff does not lift a finger. The sheriff is there to maintain the peace. So you call the sheriff, his number is 574-5400 or 574-5419, and you schedule the set out. At the time of the set out, if it's an apartment, you have to have at least 3 people available, 3 able-bodied people, right? Grandma in a wheelchair is not going to work. You got to have 3 people there to set out the property, which means take it out to the curb, not put it in the street, not leave it in the yard. It's got to be by the curb. If it's a house, you got to have 5 people, and you got to get it done in an hour. After an hour, the sheriff leaves. Okay. So make sure you have enough people on hand to do the set out, and make sure that whoever is going to be changing your locks is there during that same time. Again, because once the sheriff leaves, there's nobody there to ensure that there's not going to be a breach of the peace. Okay, that's the sheriff's job, is to make sure that there's not a breach of the peace. You don't want people fighting you over their property, or arguing over the changing the locks. So everything has to be done in 1 hour. Get your people there, get your locksmith there, and it's important that you coordinate times and get it all done within that 1 hour. A couple of important reminders are: the address has to be visible so that they can do the set out. Okay, if you own a fourplex, for example, and the number is not visible from the street, that's a problem. If you own a fourplex and there are no numbers on the individual units, that's a problem. The building address has to be visible from the street, and each unit has to be identified. Okay. Some savvy tenants who may be repeat offenders are smart enough to remove the numbers from their doors. Okay. You have to make sure that on the day of the set out, there are numbers on the doors. So if you have to go there an hour before the set out and nail a new number to the door, do it. Otherwise, the sheriff's not going to be able to help you. Okay. If you have to get there an hour before the set out and nail the building number to the outside of the building, do it. Otherwise, the sheriff's not going to be able to help you. Hopefully that won't be necessary, but I've seen it in the past, and it does happen. So it's up to the property owner, property manager, it's an investor, etc., to make sure that those numbers are visible from the street, and the numbers are on the doors. Okay. These special moratorium extensions or requirements have been extended by the CDC through June 30th. The June 30th date really didn't concern me at all. I mean, it's been around, it's over a year now. I didn't care. What I was concerned with was that the CDC extended them. How does the Center for Disease Control have the authority or scope to affect evictions? I don't know. That's not the scope of our particular discussion today. but I thought it was interesting, and maybe you guys can talk about it amongst yourselves. Why this is a CDC matter and not something for the Supreme Court of Kentucky or someone else. But anyhow, the reason it's going to June 30th is because the CDC has decided to extend the national moratorium and not somebody else. Okay, well, I think that as far as evictions go, and I'm not sure how far we're in, that's pretty much what I've got. I do know that in the future, we have on May 4th, understanding bridge loans. On May 18th, staging outdoor spaces. On June 1st, understanding HVAC and home warranties. I would like to extend an acknowledgement and thank you to our partners. I think it's Draper Kramer Mortgage Corp, L&N Federal Credit Union, and Home Key Inspection Services.
And then we'll also be putting a copy of this recording on Facebook and in our Realtor Direct so that you can refer back to that. It will also go on our YouTube channel. I'd like to take a minute to thank Mike for sharing all this great information today, and for the Affiliates Council for putting the Industry Update series together to keep everyone updated on what's been going on with all the current changes, especially with the last year, everything that's been going on in the industry. We've seen a lot of changes, had a lot of changes. So it's been a great asset for our members to be able to see and keep up to date with some things that are affecting their business. So I don't see any questions, Mike. So I will go ahead and say thank you, and we'll go ahead and end the session. Everyone have a great day.
Have a good day. Bye.